kind of like a condensed 1.5 hour, everything you could possibly need to know about landlord-tenant law, including our rent escrow clinics, into one training. So this year we're just parsing it out. So this training doesn't go over the substantive law as much. There's some things unique to rent escrow that we'll discuss, but it will focus more on the clinic itself, representing at the clinic, and then kind of negotiating with the opposing party. My colleague Eric will co-present with us if you're here for our subsidized training. Same two people. My name is Bradley Showman, pro bono manager and staff attorney. Eric, if you'd like to introduce yourself.
Hello, everyone. Again, Eric Fanning, staff attorney. Welcome back. Glad you're all still here.
Great. All right, so let's get started. If we could do the next slide here. Okay. So our rent escrow clinic, they operate in 4 counties in Vermont. That's Addison, Chittenden, Rutland, and Washington. That represents 50% of the population of the state, and just those 4 counties. The clinics allow attorneys to provide same-day legal counsel and representation to defendants in eviction hearings at the rent escrow hearing by a limited appearance. This program makes a difference in tenants and aims to improve efficiency in the courts. When we were piloting this program, there was a study done that cases with rent escrow, eviction cases with rent escrow clinics versus cases without rent escrow clinics, and the cases with the rent escrow clinics tended to resolve more quickly, and so helped reduce the administrative burden on the courts versus counties that don't have a rent escrow clinic. So the rent escrow clinics are a really helpful way for courts to kind of manage their caseloads. I know that is still a problem for a lot of courts post-pandemic here. And all clinics are in person. Tenants have the option to appear via WebEx, and some of them do. I think that that's a good opportunity for more experienced volunteers to participate via WebEx. But we always go in person, with some exceptions, and I encourage newer volunteers and people without much experience in landlord-tenant law to definitely go in person. Next
You have
step.
a question?
Yeah, it's the rent escrow clinics, for the pro bono, is it just that 1-day commitment?
Yep.
Or it will never, I mean, not never, but it will go to like another.
That is
Is that
correct.
right?
Yep, that is correct. So it is limited it's limited scope representation just for that day. We have had volunteers like take a case, like, actually, I want to rep this one at the final hearing. And so we have had volunteers do that, but that's completely optional. And if there's follow-up that needs to take place for clients, we take care of that. So just some observations from the last year of doing this. According to research from our sister agency, Vermont Legal Aid, tenants are typically behind about $3,200 in rent on average, in the average case, I should say. In 2024, pre-pandemic, it was about 2,000. I know I personally was surprised by these numbers. I think like the larger amounts tend to stand out because we do have cases that have a much higher arrears, and they tend to stand out a little bit more. But most cases are much less than that, but it's still higher than pre-pandemic levels. And so that's been an interesting observation. The number of non-payment evictions has increased. Pre-pandemic average from 2015 to 2019 was about 1,750 cases. It was about 1,990 in 2023. And then we're, according to data from Vermont Legal Aid, we're on track for about 2,100 eviction cases in 2024. And so I give you folks that data because from like 2020 to 2022, there was a lot of rental assistance, courts were closed, all that crazy stuff. So those years, there were definitely a lot less eviction filings. But now that we're pretty much post-pandemic, a lot more evictions have been filed and courts are kind of feeling the heat quite a bit more. Another thing that we've noticed, and we talked about in our subsidized housing training, is that subsidies are being terminated in tandem with non-payment eviction filings, and that was not the case before according to my colleagues, I've only ever worked here since 2020, but according to my colleagues, that hasn't been the case in the past, and so that's happening more and more now. So concerns moving forward, there are limited public funds to help tenants get caught up on rent. So community action agencies, you might have heard of CVOEO in our neck of the woods, the Champlain Valley Office of Economic Opportunity. There's Brock down in Rutland. What's the agency in Addison? I can't remember the agency in Addison, but each county. Hope, yep. Hope in Addison, and so each county has an agency that administers funding to help tenants get caught up on rent, but only if that will defeat the eviction, right? And so if a tenant is behind 3 months of rent, they could be eligible for up to 3 months worth of assistance. But and potentially cure an eviction, a non-payment eviction, by getting caught up in rent and paying the court costs. But if they're 5 months behind in rents, that 3 months won't cure the eviction because they'll still owe rent. So they have to pay the other 2 months down before they're eligible for the funding. So it's a little bit of a rigmarole, but there is funding out there available for folks who aren't too far behind on rent, or folks who are more than that, but can get caught up with those extra, can get caught up with the remainder. There has been an increase in no-cause evictions that limit an ability to tenants' ability to stay in the housing, even when they are caught up on rent. And according to data from Vermont Legal Aid that they've studied, the no-cause evictions have decreased slightly, but are still higher than pre-pandemic. So I think we saw during COVID, when the courts reopened, there was, I think it got up to about 50% of evictions were no cause and non-payment. Now it's closer to about 30-ish%, according to data, more recent data from Vermont Legal Aid. And so no cause evictions are still high. And that's a concern moving forward. So even if tenants can get caught up, they still might lose their housing.
And one quick thing to add, these are often the no cause cases, often in tandem with or subsequent to no cause fine, non-payment fines, which provides its own layer of difficulty.
So homelessness surged during the pandemic, and it's still rising, which I think is crazy. So in 2020, there was 1,100 people experiencing homelessness during the, there's a census every January that's of each year. And it more than doubled, and then it continues to rise. So we're now at our last census was 3,200, almost 3,300. I don't have updated statistics for this, unfortunately. As of 2021, Vermonters must earn $23 an hour to afford a 2-bedroom apartment, to have that be about a third of their income. And a lot of low-income tenants, low-income seniors and disabled individuals are on a program called SSI, which is a type of Social Security for very low-income people who haven't been able to pay into the Social Security system. So it's a type of kind of Social Security folks for folks who haven't been able to work in their lives. And that assistance is capped at about just under $1,000. It's gone up quite a bit in the last couple of years, but by quite a bit, I mean like, $100. And it had not kept pace with rent. And that's the income of a lot of our extremely low income clients is SSI. So if they don't have a subsidy, it's very hard for them to afford market rate rent. And the vacancy rent for rental homes is about 3%. It's a little bit lower in Chittenden. I think Kyle said it was 1.5%, and a healthy market usually has a 4 to 5% vacancy rate. And I mentioned community action, like CBOEO, they have assistance up to 3 months. In Chittenden County, they only provide 2 months worth of assistance recently, and it has to be able to stop the eviction, so that it has to be enough money to allow the landlord to say, okay, that's everything you owe me, we're going to stop the eviction. And it will help with court costs and fees. You have to ask for it though.
Are they still helping us?
Court costs and
I
fees.
heard
They're not.
this time.
So it changes with the weather. It is, and And the reason I say that is because I had a client recently who got community action funding that covered, well, it actually wasn't my client, it was just someone that I heard about. 7 months of rent. Got 7 months of rent for community action because the rent was very low, so the dollar amount was very high, but they got 7 months worth of assistance, and you're like, well, how? Your rules say a different thing. And so it's flexible, but I don't know the circumstances in which it's a little bit of a black box to me. So I usually tell people ask for the court costs and fees because that will cure, because that is required in Vermont law to cure an eviction, is paying all the rent, the court costs, the fees. The court costs and fees are about $400.
Another situation, like we alluded to the last presentation, when in doubt, ask.
Yeah. Okey doke. And Eric, you want to take it from here?
Absolutely. But before I do, just want to give a shout out to Bradley for the picture in that last slide. I love it.
Oh.
I wish I could take that picture to be red escrow.
Everything will be all right.
All right, so volunteering with the rent escrow clinics. First of all, what is rent escrow? In eviction proceedings where rent is at issue, meaning the tenant owes and is behind on the rent, landlords can file a motion with the court either with the complaint or subsequent to the complaint, basically at any time, to ask the court to issue an order to make to require the tenant to pay their rent to the court clerk while the eviction is pending. So the court holds it in escrow. One thing to keep in mind is that it does not have to be pled as a non-payment of rent eviction case in order for the rent escrow statute to apply. All that needs to happen is that there needs to be a motion and subsequent finding by the court that the tenant is obligated to pay rent and has failed to pay rent. So even if it's just a no cause case, if the landlord can show that the tenant's behind on rent, the court would have authority to issue a rent escrow order. If this order is granted, which requires a hearing, and we'll get into rent escrow hearings, but if the order is granted and the tenant misses a payment, they can be evicted by a writ of possession simply for failing to make the payment before a hearing on the merits. So it's in many ways sort of a strict liability kind of thing, where if the payment becomes due and the tenant fails to pay into court, the statute says that the landlord is entitled to an order for possession. And as a result, to get involved at the rent escrow process really is to get involved at a critical stage in the proceedings. And it often is the first time in the litigation that the landlord and the tenant, the parties, kind of come face to face or, start talking. So a lot can happen. Volunteering at the clinic. As Bradley mentioned, we really encourage folks to come in person if they're new to the program, just because having that in-person engagement really does help. Masking policies, they're pretty relaxed at this point, although there's no requirement to wear a mask in any court, at least that I know of. But of course, you're free to if you'd like. Come to court at least 15 minutes before the first case is docketed. And we tell our clients the same thing too. If come to court, come at least 15 minutes later so we can talk. We could talk with the opposing party. Typically, those of us who work for LSV or VLA will be, in one of the meeting rooms in the courthouse, and it's usually the same one. So, just look for us and we'll be there in one of the meeting rooms outside the courtroom. And we come prepared with all of the files for the cases that are docketed for that day, along with the required, forms that, it's we have folks fill out and the volunteers fill out. Everything's included in the file. So we do those for every case. And then, of course, that means that before the case is called and, even before you meet with the clients, a lot of the times you can, look through the pleadings and issue spot. So the defendants will start to appear. Of course, how many tenants throughout the day, how many show up, really depends. And pre-pandemic and, it really used to be variable because we weren't engaging in the kind of proactive outreach that we do now. So it was really just a matter most of the time of, well, we'll see who shows up. Nowadays, we will have had contact with more folks prior to the hearing, so we can gauge that more accurately. But in any event, when tenants start to appear, clinic staff will connect with tenants who show up and basically say, you know, there's volunteer attorneys here to help you if you'd like help with your case. Most people do take us up on that, although, you know, once in a while we'll get a defendant who, for whatever reason, says, no, I'm all good, or I don't want your help, and obviously that's their call. So interested defendants will fill out an intake sheet that includes contact, demographic, and eligibility information, which is basically the same information we would be doing at intake if they just called into the helpline outside of the clinic. It's the same kind of questions we ask anyone who comes to us for help. Then clinic staff will help prepare a limited scope retainer, a pro se appearance form. This would be for the client to submit to the court so that the attorney can withdraw their limited appearance, and so that the court knows how to contact the client after the attorney has withdrawn. And as I just said, the limited appearance and notice of withdrawal for forms.
Are you required to file those in paper, or can you make a verbal motion?
Good question. The court will accept verbal withdrawals or appearances. And sometimes an issue is the tenant isn't there in the courtroom. And so that they can't, you know, sign their notice of pro se appearance, but the volunteer attorney will be in the courtroom. In that case, most judges, certainly all that we practice in front of, will allow an on the record notice of appearance by the tenant, as long as all their contact information is made clear on the record. Okay, I think we're all set here.
I'm sorry.
Oh, yeah.
For limited appearance for these kinds of clinics, is it required that there's, I can't remember the rules for conflict of interest. I mean, yeah, for conflict checks.
We're
Is
actually,
there- Are we coming up to that? Sorry.
Yeah, we're
Ahead
gonna,
of you, sorry.
no, well, it's a good question, and that's, you know, that's why we include this in the presentation. It's good information, so.
This is the next slide. Do you want me to keep
Oh,
going?
no, sorry, yep, no, this is, so, as Bradley alluded to before, you know, rent escrow hearings are, hybrid by default, meaning you have the option. You don't need to make a motion to the court and get granted leave to appear remotely. You can just sign in through WebEx, and the court sends out the hearing instructions for remote participation along with every notice of hearing. So that is an option. And, you know, tenants often do appear by phone or remotely for various reasons. And we've seen this actually be a boon for access to justice. Transportation to the court, taking time off work and things like that really has created barriers in the past. So we found that, you know, on the whole, having the hybrid option really does lead to increased participation, not 100%, but, you know, increased participation. So oftentimes a litigant will appear by phone or WebEx and want our help. So we often make arrangements to call them, you know, we'll be in court with our laptops, or, you know, if we're remote too, the court can do a breakout room, and we can, so as long as we could talk privately with the tenant before. And, you know, courts typically allow volunteers to enter a limited appearance and withdraw on the record. And
Sorry.
to your question. It's almost as if you could see what's coming. You can predict the future. So here's the rule for the conflict check. So a lawyer who, under the auspices of a program sponsored by a nonprofit, who provides short-term legal services to a client without expectation that the lawyer or the client will provide continuing representation, is subject to rules 1.7 and 1.9. Only if the lawyer knows that the representation of the client involves a conflict of interest. What does this mean? If the lawyer knows there's a conflict, they can't get involved, but they don't have to, there's, you know, a bare conflict check, right? Of course, you know, if you have the client's name and you know a conflict exists, then.
But there's no requirement that you go into your system and do the whole formal conflict check that
That's
you
right.
usually do for every client.
Well,
There's a caveat on the next slide.
well,
Okay.
I think, let's just go to the next slide.
Yeah.
So usually we send volunteers the docket ahead of time, so generally there is an obligation.
Yeah.
But yeah, so if
So if you don't, so we actually chatted about this with Mike Kennedy, and that's why we kind of adjusted this a little bit, because Odyssey changed a lot of how it practiced beforehand, because it's so easy to get the docket, to see the docket and send it off. And so if you recognize the conflict based on the docket and things like that, I think you, then you do have to do that conflict check. But, you know, if you're like at the clinic, and you're representing someone, you've done your due diligence and you don't recognize the conflict, but then as you're like, but then it turns out that maybe they are, because like you don't know, you don't recognize the plaintiff or something of the sort, I think that that's fine, right? Because you're not violating your ethical rules in that situation. Like,
Yeah.
once you dive in and then you realize, oh, shoot, that's actually so-and-so with this place, and I had no idea. And so I don't think that that violates the rules. But I think, so I think volunteers have to do like a touch more if we send them, and we usually do send the docket ahead of time, a touch more, but maybe not, but maybe, there's,
Slightly less.
yeah, slightly, I would say slightly less. I would say slightly less.
I had overlooked that aspect of this because I forgot that as a matter of course, we actually
Yeah.
do send the dockets
Yeah.
ahead of time. But, you know, in the old days, as I said, when we would have volunteers and we didn't get all that ahead of time, it
Should
wasn't a
look at-
violation of the rule. Only, it's not a violation of the rule if it does not, if it's not if you can't tell it's a conflict by looking at the.
Yeah, and I used to not always send the docket. I only sent it the docket when the volunteer would ask for it, and then I just got to the practice, and then I'm like, did I just change things? Did I just make it worse for everyone? Because I'm trying to be helpful.
Thanks, Bradley, for making us do a conflict check.
Right. But, so yeah, we did chat about that with Mike Kennedy, and
Yeah.
and so, and, you know, and if there's one case, you know, we've had volunteers who work at firms who sometimes represent landlords as well, and they'll recuse themselves from a case or two, and then, we'll know not to chat about the case, you know, with that volunteer too. And then that's worked really well in the past with attorneys who have represented landlords. Next slide. All right, so this is mine. Ethical duties. So when there's conflicts among defendants, right? And so rule 1.7 is the conflict rule. So we can't rep two clients in the same action if they're directly adverse, or there's a significant risk that your services will be materially limited in dual representation. You can rep two clients in the same manner if there's no actual conflict, and you can provide competent and diligent representation to both. Representation is not prohibited by law. Representation does not involve asserting one client's claim against the other, and each gives conformed consent confirmed in writing. That's a tough one to get in a clinic setting, because it does happen so quickly. And I don't think we have a clear answer for this piece. We do, if we do dual rep two clients in the clinic setting, it is, as long as we've done our due diligence, advise them both, that if it turns out that they part ways, we can't help them. You know, we can represent both. Typically, we can move on to the next slide. What we do is we represent the person who came to us first, and they can choose whether or not to share the information with the other person. If they want the other person to be involved as someone who's not a driver in the situation, we have to advise the other person that we're not representing them. We're not, if they have a defense, we're not going to tell them about the defense and things of that sort. It can get really tricky. And of course, when the tenants are adverse, we're absolutely not representing both. What winds up happening is that in the clinic setting, because it is limited scope services, we might be able to represent both. Very briefly, we will have a limited retainer with both, and we do have those in writing, that we're only, you know, representing you in this circumstance. And kind of you're in and out. You know, and so it tends to get really tricky. I think when there's more than two defendants and they're both present, you know, chat with clinic staff and we'll just figure out how the best way to go forward ethically. We do chat with Mike Kennedy about these things from time to time. I think we need to kind of this does remind me to kind of ping him about, these kind of conflicts issues, because they do come up. We have gotten written conflict waivers with folks. Sometimes that's just not amenable in the clinic setting because it's like 11:45 and the clerk is like, we're gonna go to lunch and you need to get out of here. And so sometimes things like that come up that makes it impractical. But this whole conversation just reminds me to chat with Mike Kennedy about these kind of things a little bit more too. But for the most part, we do meet our ethical obligations in the clinic settings. I've gotten written conflict waivers from folks and done dual representation. So it is possible. Excuse me. It's allergies, I swear. And I've been talking all morning. And when a co-defendant is not present, the court might not approve a stipulated rent escrow order, and so it might just throw out all the work. So we need to get that co-defendant involved, and we need to get that co-defendant here. So we try to get that person on the phone or on WebEx if they're not present in court. And occasionally we have problems with this. Sometimes the courts won't hear the case if if one tenant shows up and the other doesn't, which I think is weird. And I don't know why they do that, but I think more often than not, if you're stipulating to rent escrow, and there's a co-defendant who's not present, that's just going to cause some kind of problem with the judge, and that's going to be a really hard thing. So we need to try to get everyone to participate. Next step. Okay, and then these are just the regular ethical duties. These still apply in the clinic setting: confidentiality, competence, and communication. And competence. You've been at these trainings, so now you're competent. And confidentiality, where just be mindful of surroundings and volume when discussing a client's case, because I don't know if you guys have been you probably haven't been in Vermont, or you've been in Vermont courts maybe. They're very small, very intimate affairs, and it's really easy to kind of overhear something that maybe we need to be more mindful of the sound carrying and things of that sort. That would be the biggest part of confidentiality, and the communication. Obviously, these trainings will help you with communication as well, making sure your client understands what their options are and making the decisions, going over the decisions with them. Helping them weigh the pros and cons and putting them in the driver's seat. And we do limited scope retainers and kind of get these things in writing. So we've really designed the clinic in a way to facilitate our ethical obligations, because we know we're offering a really good service to clients, but we all want to make sure it's a high quality service, and it's also very clear to the client that it's a limited service. After the clinic, excuse me, a case is opened at Legal Services. And the client gets referrals or follow-up. So we'll do the answer with them, if we have to do an answer. If there's additional services that we can provide in the case, we will. And we'll take it from there.
All right, so the basics of rent into court. This basically outlines a lot of the stuff that was covered earlier on, so I don't think I really spend much time here. The tenant retains possession until one of the following happens. Tenant surrenders possession, the landlord is able to basically win an eviction case and get an order for possession, abandonment, but the landlord can't use self-help. It's pretty basic stuff. So here is where the rent escrow hearing often sort of plays out in the larger picture of the eviction process. Notice has to precede the court case, of course. The summons and complaint are served on the tenant. The summons, of course, will advise the tenant they have 21 days to answer, although the rule is changed, or the answer deadline is extended or altered if the tenant shows up for the rent escrow hearing. They have 14 days after the rent escrow hearing to answer, and we'll talk about this more a little bit, I think. Motion to dismiss often precedes a rent escrow hearing or is made at the hearing, which is allowable under the rules. The rent escrow hearing then happens, and then if the tenant shows up, if they haven't already answered, they can file an answer. And then normal litigation activities like status conferences, discovery, and trial, and then if the landlord is successful in the eviction case, they were the possession issues. So as I said before, the grounds for requesting a rent escrow order are that the tenant is obligated to pay rent and the tenant has failed to pay rent. And this is often called a motion for rent escrow or a motion for rent into court, same thing. Rent can be ordered from the earlier of the date of filing or the date of service. So whenever the case is commenced under the rules of civil procedure, either by service or filing, that's how far back the judge is allowed to go when ordering rent into court, whichever is earlier. So when the landlord commences the case. Of course, that's the maximum that the statute sets, but courts, can and do exercise discretion in issuing orders or reducing rent. And of course, if there's a stipulation between the parties, that could impact it too. Rent escrow hearings are just about money, and this comes up all the time at rent escrow hearings, either from your client or from the opposing party, from the landlord, who bring up all kinds of other issues that may have impacts on the overall merits, but are irrelevant in terms of rent into court. So one thing that I often stress to tenants who come to get help at these hearings is that the judge is not going to make any order for possession today. That is off the table. It's just about whether or not there are grounds for you to pay rent into court and what that order is going to look like. Habitability related defenses can be raised. Trial courts are basically split on how that will impact a rent escrow order, or if it will totally defeat the landlord's motion. Some judges, will say, well, that's an issue for a trial, or that's for the merits, raise that in your counterclaims and we'll deal with it then. Some judges will reduce rent into court if the tenant can come forward with some evidence that there are substantial habitability related issues. So it just depends. So a landlord has the right to request that the order to pay rent into court while eviction is pending. This doesn't have to be for non-payment only cases, as I said before. If the tenant is ordered to pay rent into court and fails to make the payment, the landlord can request and is often granted a writ of possession that is executable, that can be enforced 7 days after the tenant is served with that order. It used to be 5 business days, right? And then it was changed to reflect days a day rule. So it's 7 days, 7 calendar days.
It's the same.
It really is observational equivalence.
It's
It
basically.
makes it easy. Like everyone's speaking the same language though. So it's, but I remember when that changed, I got so on top of it, but I haven't changed my slides in the other presentation yet. So, but I did change our templates really quickly.
Yes. And some older rent escrow order templates will still have that 5-day link. So
Okay.
it's best to
Some
change.
judges will change it too. Like,
Some judges.
yeah, well, yeah, I know.
Judge Tor once didn't change it and I had to be like,
Yeah.
It should be
keeping
changed.
myself honest here.
Yeah, you're right.
That's 7.
right.
I mean, it's also, what the law says now.
Right, no, I know.
Right.
But I was on the landlord side and
Right.
I loved 5,
Yeah,
but 7 was the rules.
Yeah. Yep.
All right, so the motion for rent into court. The landlord must file a motion to obtain a rent escrow order. The motion must include an affidavit or support signed by the plaintiff. That's a requirement in the statute. As I mentioned before, the motion can be filed at any time. Most of the time, it's filed with the complaint and served on the tenant at the same time, but not always. It can come later. There are some landlord's attorneys who will wait for the tenant to file an answer and appear in the case and then file a motion to pay rent into court. But it depends. So the tenant must get at least 14 days notice of the rent escrow hearing. If notice has not been given to the parties of the tenant at least 14 days prior to the scheduled hearing date, if one's already been set, the court will, upon request or sometimes on its own motion, reschedule. If it's clear that 14 days notice wasn't given. And can be filed in any eviction, but only if the tenant is behind on rent, or at least if the landlord can show that the tenant is behind on rent, which we won't.
All right, so I'm gonna go over answering briefly. So tenants get an additional 14 days to, if they haven't answered yet. And there's so they're served, what happens is a tenant served and the summons a complaint along with a rent escrow order and a hearing date. They get an additional 14 days to file an answer if they attend their rent escrow hearing and they have not previously defaulted. So what if the rent escrow hearing is more than 21 days after service? So there's some attorneys who part of their practice will file for a default judgment. If there's a rent escrow hearing pending, and more than 21 days after service has taken place. However, the court should not grant that without determining if the tenant will appear for the rent escrow hearing. I'll go to the next slide. So here's my experience from seeing these. Some courts will outright deny the motion for default judgment if there's a pending rent escrow, so they won't even consider it. Many courts will wait until the hearing takes place. If the tenant doesn't appear, they'll ask, do you want a default or do you want your rent escrow? But we have seen one judge grant a default judgment when there was a pending rent escrow hearing. And then we got that set aside. And the reason is to grant a default judgment, the time to answer must have passed. The rent escrow statute provides additional time. The Vermont Supreme Court favors participation over default. And the court's hearing notice explicitly states that a tenant gets 14 days to answer if they appear. And so this is something, and we can pop open the sample hearing notice. And so this is something that some opposing counsels will bring up, say, well, your tenant hasn't answered yet, they're in default. And thank you. If we can, I wonder if we can zoom in a touch. Yeah, so the hearing notice itself, we want to look at the middle paragraph. Thank you, that's great. If you come to the rent escrow hearing at the date and time above, you will get another 14 days after the hearing to send the court your written answer to the landlord's complaint. You must also send a copy to your landlord's lawyer. However, if you do not come to the hearing and you do not send your answer within 21 days of the papers you were served, you may lose the case without another hearing. And so the court's hearing notice itself says you get another 14 days after the hearing to answer. The statute, the reason I'm going over this ad nauseum is that the statute says you get 14 days to answer if you haven't previously defaulted. And so some landlords, attorneys will think that that means that you can get a default judgment. We've seen the default judgment granted in one case, but that was set aside within an hour.
Pretty quickly.
Yeah.
Filed the motion to set aside and, the judge took a look at the hearing notice that I attached to the motion
And said, yeah, that was an error. The time to answer actually had not passed yet, because by statute, you get more time, right? And so even though typically and I think putting it that way makes a lot more sense. Like, I think typically you get 21 days to answer, but the rent escrow statute expands the time to answer. That's something that you might just have to explain. I think it comes up with pro se landlords quite often too, is that your client hasn't answered. Like, well, I can just get a default judgment. That's not the case. That said, we can't advise tenants that there is absolutely no chance whatsoever that they will get a default judgment or any of that will happen. We can advise, what we do advise them, at the clinic, you won't deal with this as much because you're there. But what we'll advise them is that, we'll help you with the set aside if that happens. And, but advise of the risk and things of that sort. So long story short is I just wanted to just emphasize, because it is something that occasionally comes up in the clinic setting. I think the vast majority of plaintiffs' counsel and plaintiffs understand that tenants get an additional 14 days after the hearing to answer. Sometimes it does come up and you should just be prepared. The statute itself expands the time to answer. Courts typically will not grant a default judgment. Tenant is not in default. let's gonna get along with, let's get to the meat and potatoes of the issue and kind of litigate. All right. And if we could, I know I make it hard on you, Maya, to opening link.
No, this is the next slide.
Okay. Okay. So will a tenant, yeah, it's unlikely but not unheard of, and they will have strong grounds for a set aside. And we have definitely had courts set aside the judgments on this ground. And next slide. Okay. So, so when you're meeting with the client, you and the clinic staff may have had a chance to review the filing for filing for defects and things of the sort. Most of these days, you'll have a chance to just have time to review. Sometimes you won't have had time to review, but for the most part, you'll have had some time to look over the filings while we're working with clients and things of the sort. But before you discuss strategy, you should go over some basics with the client. So it's just kind of like, let's go to the next slide here. I think it's easy to kind of get into the meat and potatoes of the legal advocacy. And it's important to even ourselves who've done this a lot to remind ourselves, this is might be the tenant's first time in any court proceeding, and much less an eviction proceeding. And we should kind of like ease them into it before we start talking about if there's like a motion to dismiss, talk about stipulating, talk about moving out, talk about paying and things of the sort. So I think a good thing is, are you familiar with what today's hearing is about? Today's hearing is for a motion to rent in the court. Are you familiar with what that is? Do you want me to explain that a little more to you? It's like, yeah, can you explain that a little more to me? And then just kind of go into it. And then, so I try to lay it out here in a way that makes sense. Vermont, we emphasize, Vermont law allows landlords to do this, to ask that tenants pay rent to the court while an eviction is processing. Evictions in Vermont can take several months. And so this is the law's way to make sure that tenants pay rent while that process plays out. You could be asked to pay rent from the date you receive the paperwork from the sheriff, or we can help you with some other kind of resolution. But now that you know that kind of context about today's hearing, can you tell me a little bit more about your rental situation? And then, the client will tell you, kind of what happened, whether they have the money and things of the sort. Let's go to the next slide. And as you're having a conversation with your client about what's happening with their rental history, what's going on in the unit, sometimes the clients tell you, I have $9,000 right here. Can we just get this over with? That has happened to me, and that's great. Yes, we can get this over with.
Doesn't always happen.
It does. It feels really good. She's like, I was just waiting for a tax return, and boy, howdy, do I have it. Let's go.
And everyone's happy.
And everyone, I said, they got the money right here. Oh, good. Okay. Well, so, and so we want to, identify the client goals as we're discussing with the client. I think using phrases like, tell me more about that. If someone says, can you get the money? I have the money. Can you tell me more about that? Things like that, trying to get the client to tell you a little bit about what's going on. I think more often than not, clients are overshare. And so we kind of have to bring them back. But, if you have a client who's being, having trouble getting the words out, trying to just suss out, does the client want to keep their apartment, or are they looking to move? Can the client afford the apartment, right? So I want to stay. Well, okay, so what's the rent? How much do you owe? Can you get back on track with the money that you have? Sometimes the answer is yes. Oftentimes the answer is no. Does the client have an alternative housing option? Sometimes the client's like, I'm like 50% out. I could be out tomorrow. And we've had situations where we just kind of say, okay, let's stipulate and move from there. You might also want to suss out possible defenses. You will review the file to see if there's a motion to dismiss or filing defect that we can raise. And we can raise those at the rent escrow hearing. But you want to suss out other possible defenses such as habitability. Has the tenant already paid the rent? Sometimes that has happened. I frequently have tenants have at least paid some rent. when they get to the hearing. They might still owe arrears, but it's not uncommon to say, have a tenant saying, I paid $1,000 last week. I don't know what else I need to do. And so that might affect the amount owed and things of that sort. And you want to get a sense of that. You also want to make sure that the tenant received 14 days notice. For the most part, I think that tenants are getting accurate notice, but you just want to make sure that they have the full 14 days because Judge Hoare uses language like this, but he said the 14 days is important because it lets the tenant get their affairs in order, right? And especially if the tenant is looking for assistance or applying for funding and things of that sort, it is really important to give them that time to do that. And so they don't have the 14 days notice that the hearing does need to be rescheduled as a matter of law. Next slide here. All right, and I stole one of your slides, Eric, so your habitability, go right ahead.
Don't worry. So some tenants come to the rent escrow hearings with complaints about the condition of the apartment. And in fact, that often is like the only thing that the tenant will want to talk about, depending on how bad the situation is, and we, have seen pretty awful conditions that clients have told us about sometimes. So here's what to look for in the context of rent escrow hearings. As a general matter, it's good. Your habitability arguments are going to be unlikely to succeed at rent escrow unless the problems are substantial and documented. In other words, you have more than the tenant's testimony, generally speaking, to go off of, unless they come across really compelling on direct examination and stand up well and cross.
Right.
But so what kind of documentation helps tenants prove habitability claims at rent escrow? Documented complaints made to the landlord or a third party. So the tenant has a notice that they could produce saying, dear landlord, my heat hasn't been on for a week now. Please, there's a leak in the bathroom, something like that. Town health officer or a fire marshal inspection report. These constitute actual notice as a matter of law because when a fire marshal or town health officer inspects a unit, they're required by law to give the landlord that inspection report. So that is actual notice as it's defined under the Residential Rental Agreements Act and in this context. How serious is the problem? Is it a broken, counter, handle, or is it no heat or running water, or anything in between? What losses has the tenant suffered? And these can be documented in a multitude of ways. Days the tenant had to take off work to try to resolve the problem, out-of-pocket expenses, in extreme cases, pain and suffering. But there's a lot of ways to look at that. But these are the kinds of things to keep in mind when assessing habitability claims at rent escrow. And as I said before, insufficient evidence or non-material or not serious complaints are unlikely to lead to a reduction in the rent escrow amount or a complete denial of the rent escrow order. There is some case law out there, mostly like trial court opinions. That's, we've seen the court has reduced rent, for minor things modestly. So I don't think it's completely accurate to say that if the things are minor, you're not going to get any reduction. It's just unlikely, or at least unlikely to have a substantial result. So, big issues, serious issues that are well documented are the most likely to have an impact, if at all. You have a question?
Yes, I'm just trying to get a sense of how much time do you have at a rent escrow clinic to solve this out?
Sometimes not very much. And that's, kind of the situation that you have to deal with. Time is a factor in a lot of the rent escrow clinics. And Bradley, you want to?
Yeah, and with habitability, one thing is that that's the tenant's point to establish that they have something that they want to raise. And so if they're not prepared to make that defense that day, they might still be able to raise it in their answer, but it might not be an effective defense at rent escrow.
That's what we tell them in the interview.
Yeah,
Unless they came with their file
right.
showing the
If they had
inspections, and
Yeah.
maybe that happens once in a blue moon.
It's more often than not, the tenant will not show up with any documentation.
And and I think these are good we don't litigate habitability a ton. But I think for an effective habitability case, it does require workup beforehand. Sometimes clients will contact us beforehand and we'll have them as an active client. We've subpoenaed the fire marshal to come testify at rent escrow hearings, and they will come prepared to testify about the conditions of the unit. I'll go over a little bit more of that in our habitability presentation tomorrow, virtually. But you're right, this is the tenant's time to have brought the evidence, and if it's not there, we're in a bad it's difficult to raise it because they don't have the evidence.
And keep in mind, regardless of whether or not the tenant raises a habitability defense at rent escrow, in no way causes any prejudice to their ability to raise it later, rent a counter. Right. They can raise it at rent escrow, and maybe the judge will say, I'm ordering full rent. They could still bring counterclaims. They could still have their day in court on that issue. If they don't bring it up at rent escrow because we just don't think it's a meritorious argument for that day, they can still raise it later.
How long are these clinic days?
It's usually a morning or an afternoon. And it's usually a full morning or afternoon. So it starts about like 8:30 to noon, or in Addison, it's like 1 to 4.
Yeah, it depends on how many cases are scheduled, but they're always block scheduled. So it's not like you have 1 or 2 cases and then, oh, what am I gonna do for 3 hours and come back? No, they're happening in a blocked off morning or afternoon. The clerk in Chittenden County still schedules like intermittent status conferences and rent escrow hearings, which, so sometimes those are kind of breaks, as if you want to call it, in the blocks, but generally they're block scheduled and it's a morning or afternoon. So where are we?
5:31.
Okay. So fact patterns vary greatly, like anything else in the law, facts matter and it depends, but here are the, general, common situations you may run into. The tenant can't pay or the apartment is not affordable. If that's clear from your interview with the tenant, then you can, depending on what the client's overall goals here, try to negotiate a stipulated move-out date, waiver of back rent and claims. This is often called cash for keys. The client agrees to give up possession if the tenant agrees to waive money damages, things like that. If the tenant, wants to, can afford to pay something in the meantime, maybe it's more advantageous to try to stipulate to rent escrow so that the client can keep the apartment until they find something. Maybe they're not in a position to guarantee a move out date just then, but they have some money to pay, and that kind of agreement can be worked out. The tenant can pay rent, but catching up will be hard. Again, you could try to negotiate a stipulated move out a deal, negotiate a payment plan. Maybe a rent escrow order by stipulation, whereby the tenant also elects to try to make back payments in addition to try to, get caught up on the rent. We often refer the clients to community action, other resources to try to get caught up. If the tenant has a rental subsidy, and this is something that came up in the last presentation on subsidized housing. We can try to negotiate a settlement whereby the landlord agrees to give a neutral reference, complete the landlord certificate saying that the tenant is leaving in good standing. That's basically what those certificates say. And that the tenant is, owes no rent, or the landlord has agreed to waive the back rent. Compliance with the eviction rules matter a lot. And, as we said during the last presentation, sometimes still, even if you have like the tightest, foolproof language in the STIP, the PHA may, on its own authority or its own discretion, still try to terminate a subsidy. So one thing to keep in mind, but if there is a rental subsidy and the client just has no hope of keeping the apartment, this is often still the best bet. If the tenant has moved out and the remaining issue is money damages, negotiate a waiver if possible, or consider the tenant's income and assets if a payment plan is advisable. there's some case law that says that the tenant has moved out and it's just an ejectment, then the claims for money are moot anyway, but it just depends on how the case is played.
And there shouldn't be rent escrow ordered if the tenant has moved out,
Yes.
because there's no rent owed.
Right.
Right,
Because the rent escrow orders for the rent moving forward
right.
Exactly.
while you're in the.
Right, yes. All right, so, based on our experience, these things typically happen on 3 tracks. We stipulate to a rent escrow order, we stipulate to a move-out deal, and a writ of possession, like what we call a kind of a universal settlement. And then, or a contested rent escrow hearing. Contested rent escrow doesn't happen very often, because, it might wind up with the tenant having to pay anyway. And so we really want to try and negotiate something that the tenant can afford, so that they can start paying to mitigate the landlord's damages about rent, but also, have a place to live while they're looking for something else. And so negotiating with the opposing party, it's not scary talking to the landlord or the opposing counsel. And, often, all very reasonable people. It is more challenging to work with pro se litigants. I think my experience with pro se landlords is that I try to be respectful and mindful of the situation that they're going through. That's very scary for them. But they see me as the lawyer for the tenant, and which I am the lawyer for the tenant. I'm not helping them. And so, it kind of gets hackles up a little bit. So that can require a softer touch. I much prefer working with opposing counsel. And try to assess the landlord's goals. So is the situation just about rent, or are there underlying problems? So even if there is not payment, there might be some underlying problems that the landlord doesn't want the tenant there anyway, or really needs the tenant out very quickly for some reason. Trying to kind of like suss out where the landlord's coming from, and trying to determine if the opposing party is going to stipulate to rent escrow or move out, if that's what the tenant wants, right? Occasionally, contested hearings are necessary if the parties are too far apart on anything. But I think more often than not, these things tend to resolve in some kind of agreement. I say that I'm probably never going to get a stipulated rent escrow order for like the next month. All right, let's go on to the next slide here. And I think this is you. Back to you, Eric.
Yeah. So when it comes to stipulating to a rent escrow order, basically the first thing, or one of the most important things, is, well, how much is due? How much are we talking about here?
And Eric, we are at 2:00, but I think take another 5-10 minutes.
Oh. Time flies.
Time flies.
Okay, so what we're talking about here is how much money's on the table, how much the tenant is gonna pay, when they're gonna pay. The order has to, of course, state the consequences for not paying. Template rent escrow orders always include this language, and basically, do we have one linked? I don't know if
we don't have them linked.
Oh, wait, actually, we do in the next slide, so.
Okay.
So you can look that up on your own time, but the major things are, the tenant is, based on the evidence presented or stipulation, the tenant is required to pay X amount of money. That must be paid by such and such date, and then after that, X amount of money by whatever date of the month. So typically what happens if there's an agreement, the stipulated order is presented to the court for approval. Sometimes the judge will just approve in chambers, and the court cancels the hearing, that the parties don't have to go before the judge. A big part of what happens if there is a hearing and the hearing goes on the record is that the judge will try to, make sure that the tenant understands what the order says. Have you been advised on answering? Have you been advised on basically your various, have your options been presented to you? And then usually the judge approves the order. And then the clerk will bring the signed stipulation to your client to sign. And there's also a notice of, an acceptance of service that the tenant usually signs in court. Generally speaking, rent escrow orders have to be served on the tenant by a sheriff. So when we're in court stipulating, we usually advise the tenant, well, waive service, because otherwise they would have to pay a sheriff to serve you, and that could fall on you later. So it saves costs. Okay, and universal settlement. So sometimes the outcome of a rent escrow clinic hearing can be a full settlement of the entire case, not just stipulating to an order. The whole case is going to be resolved. So we do come to clinics with draft settlements templates that we often use. The major terms that are outlined in these settlements or stipulations are the move out date, the issuance of a writ. If we're talking about a move out date that is longer than the 60 days before which a writ would expire in most circumstances, the parties sometimes stipulate that the writ will issue on a date certain sometime later on. These can get kind of thorny, but it just depends. How will the writ be served? The condition of the unit dismissal after move out to check for damages. So most of the time we're agreeing to, or the tenant would be agreeing to broom clean. How and when will the keys be returned? Not always included in the written settlement, although that's oftentimes a good idea to make sure that that's understood and clarified. Payments to be made into court between now and the move out date. If there's a payment, sometimes the landlord will make a payment to the tenant if they agree to move out by a date certain. So that should be incorporated in the settlement as well. Some judges will request a rent escrow order and stipulation if this is in the agreement. So if there's going to be any agreement that the tenant is paying into court, there needs to be a rent escrow order in conjunction with the settlement. And this is what I alluded to before. This is, this is pretty bare bones, but contains most of, the settlement terms that I just alluded to. So the date the tenants agree to vacate, when the writ can issue and execute, service of the writ, waiver of damages, back rent, so on and so forth, condition of the property. Of course, the parties are free to agree to settle or stipulate for whatever they want. So it doesn't have to be just this, but this is what we often use as a starting place when we're negotiating settlements. So a contested rent escrow, I'll try to be really quick, let's go over. The rule allows for opposing a rent escrow motion that needs to be done in pursuant to Rule 7. And that needs to be accompanied by an affidavit if you're opposing a motion to pay rent into court. What are the typical arguments we see? The case should be dismissed. There's a legal defect in the notice. The court doesn't have jurisdiction to issue a rent escrow order. Premises aren't worth what the landlord's claiming. There are habitability issues that would impact the value of the apartment. I've been locked out. The tenant's been locked out, so there's been an illegal eviction. The tenant does not actually owe the rent asserted by the landlord. Again, it goes to factually, how much money is on the table. VRAP
It's done.
VRAP is done,
Take that
so
out.
we can take that out.
That's why I don't send the materials ahead of time.
All right, pay and stay. So here, where you have a situation where the tenant, your client, does actually have the money. The landlord, they can agree to keep the apartment if they tender and pay the rent. So this is the statute 12 VSA 4473. 4773, right?
4773. That's why I don't send the materials out ahead of time.
Vermont law permits tenants to stay in their home if an eviction is for non-payment, they become current on the rent, and they pay the filing fee and service costs. Plaintiff does not need to give permission. So this is a statute that basically guarantees the right of a tenant to keep their apartment if they pay all those costs before a writ of possession is executed. And that's an important part of the statute. This is not just pre-judgment. It's anytime before the execution of a writ of possession.
Mm-hmm.
So even if the tenant loses at trial,
Right,
or gets a default judgment, for example, issued against them because they didn't answer, and the amounts are set forth in the judgment, and the tenant's like, oh, okay, I was able to get all that, and pays it to the court, the court shall discontinue the action. That's not discretionary. As long as all the funds provided for are there, then the eviction should be discontinued, but only if it's just a non-payment of rent case. Can only redeem once in a 12-month period. The Vermont Supreme Court has made clear that attorney's fees are not required to cure in a non-payment action. And then, of course, if the plaintiff doesn't agree that, okay, this is all the money, we're good, we'll dismiss the case. That request under the 4773 statute should be brought by motion.
That's it? Any questions?
Strategy wise, for a motion to dismiss, would you ever wait until later to,
So,
I mean, I know that you